The Supreme Court has agreed to hear a federal right-to-work case next on your Labor Minute. Hello, I'm Mark Harrison. It's called Janus versus AFSCME, and we begin with a reaction from the union's president, Lee Saunders. This case is yet another example of corporate interests using their power and influence to launch a political attack on working people and rig the rules of the economy in their own favor. Indeed, the U.S. Supreme Court has decided to hear 11 cases out of 2,000 petitions, and this is one of them. Right to work is not new to the court, who in 1977 ruled in the case Abood versus the Detroit Board of Education that unions could indeed collect dues from workers refusing to join the union, provided they didn't have to pay for any political activities conducted by that union. Now, those activities include get out the vote efforts, but a point often misunderstood is that unions are forbidden by law to give union-collected dues money directly to candidates. Last year, the court heard the right-to-work case Friedrichs versus the California Teachers Association, but the court ruled in a 4-4 tie following the death of Justin Antonin Scalia, which meant the ruling of the lower court in favor of the unions would stand. Right-to-work advocates and operatives from Koch brother-backed entities and the U.S. Chamber of Commerce were quick to find the Janus case in Illinois and work to drive it toward the Supreme Court, going so far as to request the appellate court rule against them as they purposely steer the case toward the Supreme Court and a new conservative justice in the form of Trump appointee Neil Gorsuch. To be sure, a ruling against AFSCME is highly likely. Of note, this ruling would not impact private unions. I am Mark Harrison with your Labor Minute.